Well, hello there. It is great to see you again, and welcome back to the latest installment of Closing Arguments. I'm your host and moderator, Ryan Ruff, and we've got the star of our show, as always, Mr. John Razumich, or Jack Razumich, as those closest know him by, joining us in just a few moments to dive into another criminal law-related discussion. If you were able to join us for our last episode, you know that we took a deep dive into really a forgotten legal landmark. That's the United States versus Shipp case. We got through part one. Today, we're going to be covering part two. There's still a lot to unpack within this case. We'll be bringing Jack on in just a moment to dive into what, these odds and ends look like and kind of the fallout of the case, the aftermath, and then, of course, the legal arguments and the trial itself. So there's a lot of good stuff that we're going to be getting into today regarding this case. We'll also, of course, for those of you that may have missed part one, we'll carve out some time to give a quick overview from Jack as to what went down in part one. But also just a quick note for those of you that are joining us live today on the Facebook live stream. We appreciate you being here. Hey, one of the benefits of doing this thing live and joining us here on the live stream is the ability to leave a comment or even a question below. So throughout the course of today's episode, if there's anything that is intriguing to you, or maybe you have a question that you'd like answered, feel free to drop it in the box below. Jack and I will carve out some time to make sure we address those comments and questions as a thank you to you guys for being live with us here today. Now, on the flip side, though, if you're joining us maybe on YouTube or a podcasting platform afterwards, all the same, still appreciate you being here. Maybe we'll be able to have you live with us next time around. And if you need any indication as to when we're going live, you can always head over to the Razumich and Associates Facebook page for that information. So with that being said, hey, let's go ahead and bring on the star of the show, Mr. Jack Razumich, to get today's conversation rocking and rolling. Jack, good to see you. How's everything?
Hey, Ryan, not too bad. As we're recording this, we're a couple of days away from Snowmageddon 2022 here in Indianapolis. So fingers crossed for all that.
Yeah, battening down the hatches, indeed. Well, hey, Jack, I know you've got a few housekeeping items that you wanted to mention before we get into today's conversation. Obviously, we're seeing you, I believe, through a new camera today. Talk to me about that.
That is correct. We do listen to the comments. We do read all of them, even the mean ones. So we are aware that the equipment that we've been using previously was not necessarily up to snuff. The good news is we had always intended to order new equipment. So for those of you who are watching, hopefully you can see the difference. For those of you who are listening, hopefully you can hear the difference. That equipment did not arrive before the last episode, but we do have it set up now. I do want to say a special thanks to Sam Johnson and Moondog Photography for helping me to figure out what accessories I needed to make all this work, and to Rob Branch from Rabbit Hole Podcast in helping me to make sure that my office was not more of a fire hazard than it normally is with all the extra cables strewn about. If there is an issue with the video quality now, it's Comcast's fault. We've done everything on our part to do that. It is now an internet issue with Comcast. We are limited and subject to their whims like every other Comcast member is.
Indeed,
but,
indeed.
That's where we
I'm
have
in the
that.
same boat. I'm in the same boat. Well, hey, look, it's great to obviously have the upgraded equipment. So I'm excited, obviously, not only for today's episode, but all the great conversations we're going to have moving forward, Jack. Let's do our audience a little bit of a favor here. For those that may have not joined us for part one, which would have been the last episode where we detailed the case of United States versus Shipp, could you maybe kind of give us a little bit of a consolidated overview on this case to bring us up to speed as to, where we left off, really?
Absolutely. And that's the other housekeeping tip I wanted to go into for the benefit of people who are listening on the podcast platform of their choice, whether that's Audible, Podcast Addict, Spotify, Apple Music, anywhere like that. We are aware that there was an issue with episode 5 that has been re-uploaded. Previously, it had cut off at about the 32-minute mark. We got notification that has been fixed. So by the time this episode goes up, you can listen to both of them back to back and get the complete story. For the benefit of those who missed the first episode, again, here is your content warning. This is dealing with a sexual assault as well as a racial lynching in the South in the early 20th century. To hit the high points of it, going over my notes, back in on January 23rd of 1906, a young woman by the name of Nevada Taylor was stepping off of a train and was ambushed from behind. A leather strap was put around her neck. She was told that if she screamed or made any noise, the person who was choking her would kill her. She wakes up maybe 30, 40 minutes later, knows that something has happened, runs to her father, reports the fact that she's been assaulted. From there, within the next day, the local press in Chattanooga, Tennessee, which is where all of this happened, they report that a Negro brute was responsible for the attack. This is extremely important for the background of our story because Nevada Taylor did not in any way, shape, or form make an identification of the race of her attacker. Her comment was only that it was a man's voice. She couldn't see him. She couldn't identify him, but the press runs with the concept that it's a black male. The day after that story comes out, the local sheriff, John Shipp, the governor of Tennessee, and the county judge for Hamilton County, which is where Chattanooga is located, offer a $375 in cash reward, which adjusted for inflation from 1906 to 2022 is the equivalent of somewhere between $9,000 and $10,000 of cash. They offer a reward for any information leading to the arrest of the person that attacked Nevada Taylor. Ed Johnson is identified by the town drunk, a guy by the name of Will Hickson. Ed Johnson is very quickly arrested, very quickly identified as being the perpetrator of this crime, despite the fact that he had what most people would consider to be a rock-solid alibi. He had about a dozen people who were capable of stating that he was at the Last Chance Saloon, which is where he worked on the night of the attack. Sheriff Shipp, realizing that keeping Ed Johnson in Chattanooga while the case was pending trial, decided that moving him to Nashville for his safety was the appropriate thing to do. This is an incredibly good decision because over the next 2 days, the Hamilton County Jail in Chattanooga was under siege by people who were looking to lynch Ed Johnson. In fact, during the pendency of the trial, which we'll get into in one moment as a recap, Ed Johnson was being housed in Tennessee. It comes back. He's arraigned very quickly. We're about 5 days from the attack. Ed Johnson gets arraigned. The judge appoints 2 attorneys to represent him. Unfortunately, neither of them have ever handled a criminal case in their entire life. So a retired judge comes out of retirement specifically to volunteer his services to Ed Johnson to make sure that he gets as fair a trial as he possibly can. The judge advises that he's not granting any continuances. He's not granting any change of venues, and the trial is going to happen in 10 days. At that trial, given all of the pretrial press and pretrial publicity, Nevada Taylor has now taken it unto herself that she was attacked by a black man, and more specifically that she was attacked by this particular black man, Ed Johnson. The trial is at best a clown show. During the pendency, during the jury deliberations at one point in time, one of the jurors, Nevada Taylor, is recalled to the stand to answer additional questions from the jury. One of the jurors asks her to state positively that this was the Negro that attacked her, kind of giving into the bloodlust, giving into social pressures, however you want to phrase it. Nevada Taylor says that she believes that he is the guilty man. One of the jurors leaps over the jury box barricade and tries to attack Ed Johnson, which is, as most of you can probably appreciate, extremely out of the ordinary. He has to actually be restrained by his fellow jurors. And then afterwards, he's sent back to continue deliberations, despite the fact that he yelled out into the court record, "If I could get my hands on him, I would tear his heart out right now." To no one's great surprise, Ed Johnson is convicted. And where we ended up leaving off our last episode, the judge has indicated that he is condemning Ed Johnson to death. He told the attorneys, don't bother appealing it. He can either die at the hands of the law or the hands of the mob. This execution is taking place in 30 days in the basement of the courthouse. So again, just everything is moving very rapidly. Everything is moving very haphazardly, and absolutely in a travesty of what we would consider to be justice. And that is our, I don't know, 5-minute summary of last
I gotta
week's
say, you did a
episode.
fantastic job of consolidating that. For those of you that were with us for the last episode, you'd understand what I'm saying. For those that might want a little more detail, head on back and check out episode 5. There's a lot of fireworks in this case, specifically in the courtroom, as Jack just mentioned. A lot of interesting information. One thing that I know, Jack, obviously we're going to get going here in part 2 in just a moment, but a really interesting part of this whole conversation in part 1 was the role and the power that the media and the press really played throughout this process, and how that really kind of stoked the fire and led people towards Ed Johnson to begin with. So again, head on back if you missed our last episode. But Jack, let's step forward now into part 2. Walk us through what became the demise really of Ed Johnson.
Sure. And again, as I said, we're very clearly dealing with the lynching. As I mentioned last time, unfortunately, Ed is not going to live to see the end of this case. It's a remarkable tragedy. The next people that really come into this case as far as important players on this are the attorneys Noah Pardon and Styles Hutchins. And Mr. Pardon and Mr. Hutchins should go down as living legal legends. The arguments that they made or will have made in Ed Johnson's case as we move forward, they were completely right about everything. And we'll go over that kind of a little bit clearer when it gets to the recap point, because it'll make a little bit more sense then. But the problem that Noah Pardon and Styles Hutchins had, unfortunately, is they were Black attorneys in the South in 1906. They, as such, did not get the same recognition that they should have. They have very much fallen by the wayside of history. A lot of times in historical legal contexts, you'll get the occasional judge, the occasional attorney. It's mostly the defendants that we remember in them because the cases are named after them. Honestly, as far as I'm concerned, there should be statues to these two attorneys. They were that good and that competent in a situation and a time frame when that was not considered to be expected. But they're the next attorneys who come into this case. They were not officially part of Ed Johnson's legal team. In the circumstances that were leading up to it, again, remember this is 1906. We're in Chattanooga, Tennessee. This is not exactly a very equal rights friendly area. And even though Ed Johnson was also Black, Styles Hutchins and Noah Pardon were not allowed to participate in the defense of that case. The way that the court system was set up in Tennessee is that the only cases that Black litigants could be involved, Black attorneys could be involved in were cases where all the litigants were Black. So you have a Black plaintiff and a Black defendant in this particular case because it was a state prosecution. They were not allowed to participate in that. So they unofficially helped with the defense. They were actually the they were actually the attorneys who were very instrumental in helping track down Ed Johnson's alibi witnesses at the Last Chance Saloon. So they weren't officially part of the case. They did help around the margins that way, trying to help get those alibi witnesses. And they were, of course, very well aware of everything that was going on. It was hard not to be aware of everything that was going on in Chattanooga at the time. So Ed Johnson's been condemned to death, and his father shows up at their office basically begging them to take Ed's case on appeal. Because, again, remember, his three existing lawyers, the two civil attorneys who their names have mostly been lost to time, and Lewis Shepard, who valiantly put up every single fight that he could to make this work out. They basically told him, like, look, the judges said this is what's happening. There's nothing for us to appeal. Just sorry about your fate. So Ed Johnson's father is basically begging. It's like, look, no one is taking this appeal. No one is doing this. You have to do this. and he was turned down at first.
Wow.
Noah Pardon was extremely reluctant to take on the case, and part of that was very much the sensationalism of it. Part of it was the background information with regards to you have a white female victim and a black man accused of it. There were safety concerns that he had for himself and his own family, and he absolutely refused to take the case. The reason that they did get involved is that Mr. Hutchins basically cajoled and effectively bullied him into taking it. The argument being that, we have an obligation under law. We have an obligation to the helpless. We have an obligation to people who look like us. No one else is going to do this. If not us, then who? And, eventually Mr. Pardon kind of relented and they came onto the case. So the first formal appearance that Mr. Pardon and Mr. Hutchins have is on February 13, 1906. So this is 4 days after Ed Johnson's been condemned to death. And they are in front of Judge Samuel McReynolds, our old friend Judge McReynolds, the guy who wouldn't move the trial, who wouldn't grant continuances, who did everything humanly possible to try to move this case as quickly as he could.
Yeah.
They're in front of that judge again, and they're asking for a new trial. And the argument that the attorneys are using is something that would very clearly be understood as a basis for a new trial today. They're arguing that there was significant doubt about Mr. Johnson's guilt, basically a situation of, again, we've got 12 eyewitnesses who say he wasn't there and a town drunk who says that he saw him in the area. That's pretty reasonable doubt. Oh, and his previous lawyers abandoned him by convincing him to waive his right to appeal, which even back then, again, this is all very nascent, but everyone understood you still have the right to appeal a conviction. But his attorney's telling him to abandon it. That seems bad. That seems like maybe a basis for retrying this case.
Yeah.
That did not work, as I'm sure you can imagine. Judge McReynolds, citing a local rule that mentioned that request for a new trial needed to be filed within 72 hours of a verdict, the case was, the issue was considered moot. And in shades of how some things how the more things change, the more things stay the same. It's not quite that short a period of time these days, but that is a very technical rule that most modern courts will adhere to. The idea that, okay, this is the procedural rule that needs to be followed. If you're not following the procedural rules, you're not getting it. So that argument didn't go. The argument was like, well, it's been more than 72 hours. Sorry, you don't get your new trial on that.
Jeez.
The next argument that they made, and sorry, let me back up a second, because I've actually got a quote here that I want to go over. Because again, remember, this is all back. This is fascinating stuff. This is back when stenographers have to take these things down by hand. So there are these giant paper ledgers in these old law schools and law libraries and what have you, where you can actually read what's written out on this stuff. And in addition to throwing out the request for a new trial, Judge McReynolds, just to give you an idea of, again, the type of person that we're working with, Judge McReynolds on the records dresses down the two attorneys, saying, what can two Negro lawyers do that the defendant's previous 3 attorneys who were unable to achieve? Do you think you know the law better than this court or the lawyers who represent the defendant? Do you think a Negro lawyer could ever be smarter or know the law better than a white lawyer? It was a lovely time.
Wow.
So,
yes, one could say. Oh
yeah,
my goodness.
So things have not improved is probably the short version of it.
Sure.
So now that they have a new final judgment to appeal, because judgments come off a final judgment. So the first issue was like, okay, we have a verdict. That's a final judgment that can be appealed. We have made a motion for a new trial. That is something that's been denied and is now represents a final judgment that can be appealed. Pardon and Hutchins were smart. They did know the law better than Judge McReynolds, because they used that final judgment from Judge McReynolds to appeal that to argue that they were entitled to a new trial. So taking Judge McReynolds, which I can guarantee you did not make him very happy.
Oh my gosh. But well played, but touche. Well played.
Right. So they appeal that up, and they do that within the appropriate procedural time limits for filing the appeal. So on February 20th of 1906, a week later, Hardin and Hutchins file an appeal with the Tennessee Supreme Court, as well as a writ of supersedis, which would basically be, it's a fancy Latin term. It's basically a request for an order to not do something, is what that is. And they filed that writ requesting an emergency stay of the execution. That was denied by the Tennessee Supreme Court on March 3rd in 1906. Now, remember, we've only got until March 13th before they're due to hang Ed Johnson. So the clock is ticking down. So they filed a request with the Supreme Court looking to appeal the denial of the new trial. That gets shot down. We've got 10 days left that we have to work at. So here's where the absolutely legendary thing happens, which is why this case is so important as far as its precedential value. You've got 10 days until Ed Johnson is scheduled to be executed. You're out of options with the state of Tennessee. This is where you throw what's referred to, this is where your Hail Mary pass comes in. So what Hardin and Hutchins do is they file a petition with the United States District Court in Knoxville, Tennessee, under the Habeas Corpus Act of 1867. And the reason that this is a huge Hail Mary pass is no one actually knows what the Habeas Corpus Act of 1867 does. The law was passed, obviously, like it says, it was passed in 1867. And all it said was that the Habeas Corpus Act allowed defendants in state criminal actions to request that a federal court review the case if the defendant believed that there had been prison in violation of their federal constitutional rights. This is before the concept of incorporation. Incorporation is a subject that we'll talk about in a future episode, but just to kind of hit the high point, the Bill of Rights, the federal constitution, those rights were originally restrained the federal government. They started to apply to the individual states through a legal mechanism that's referred to as incorporation, where the 14th Amendment applied those rights to the states. The Federal Habeas Corpus Act of 1867 came along with the 14th Amendment. It was part of the enforcement mechanism of the 14th Amendment, but it had never been tried before. No one knew what the Federal Habeas Corpus Act actually did. So the idea that they were going to file in the federal courts for a review of the state court decision, no one had ever tried it before. This is legitimately new legal ground. This is something brand new. These are the first two attorneys who have ever tried this. These are two black attorneys who have just been insulted by a judge, that they don't know the law as well as he does. They used his own order against him to kind of appeal that. You know, they've been told that they don't know the law as good as any white attorneys, and they're doing something that no white attorney has ever done. And the important thing is they're doing it right, and it works.
That's awesome. I mean, no wonder we're talking about a forgotten legal landmark here. I mean, boy, is that just, I mean, it's awesome. That's just a great word to describe that action by the. All right, keep us going, Jack. Where do we go from here?
So what happens is the petition for habeas corpus, which is the same type of petition for habeas corpus that still gets filed now, over a century later in 2022. They file a 9-page petition with the federal court that argues that Ed Johnson's lawyers were denied the right to file pretrial motions. That's correct. They weren't allowed to file motions for continuance. They weren't allowed to file motions for change of venue. The trial was unfairly influenced by the threat of mob violence. That's a given. You know, they did try to storm the jail for 2 days. Only white people were summoned to jury service. While that was technically correct, that was unfortunately not something the courts would address for another half century, but that's a side issue. And that Mr. Johnson's lawyers had abandoned him by advising him that he waive his appellate rights. Those are all federal constitutional rights to a fair trial, fair representation under the 5th and 6th Amendments that would technically fall under the Federal Habeas Corpus Act. They even brought up the other irregularities, like, you know, the juror attempting to attack the defendant in open court. So the district judge for Tennessee at that time, C.D. Clark, ordered that a hearing would be held on March 10 of 1906. So again, this is 3 days. This is 3 days before Ed Johnson is ordered to be executed. The federal government steps in, the federal judiciary steps in and says, no, we want to hear this. So again, this is everything coming right down to the wire on this.
And that's been a recurring theme, Jack, throughout this whole. I mean, you want to talk about fast and speedy trials. This is what, we have been experiencing it from start to finish through this entire thing. So given that consolidated timeline, I feel like it's worth emphasizing how important it is that the federal government stepped in, in such a consolidated amount of time. Nowadays, obviously, we know the federal government's not really do too much in such a fast amount of time, but here they are stepping right in, at the 11th hour, if you will, to interject and to keep things rolling. So take us further.
So they managed to get the hearing, and they expedited the hearing on March 10, and the hearing lasted for about 8 hours. And among the witnesses who were called, they called Mr. Johnson's 3 original lawyers, who all testified under oath and signed affidavits that the threat of a lynch mob influenced their decisions. Because again, when they told Ed Johnson to abandon his right to appeal, they were very cognizant of the idea of like either he dies at the hangman's noose or he dies at the mob's noose, and we don't really want to die at the mob's noose either. So that influenced their decisions absolutely as far as the advice that they gave to him. They called a deputy clerk in the Hamilton County Clerk's office who testified that he could only remember one black person ever having been summoned for jury duty in Hamilton County. The district attorney was called and argued that there was no violation of Ed Johnson's federal rights, which, remember, at this time weren't exactly well defined what those were. And Judge McReynolds gets called in by a writ of mandamus from the federal court. And his position is that, in his opinion, as the judicial officer that oversaw the trial was absolutely fair. I'm sure we're all shocked by that.
Sure.
So what ends up happening is Judge Clark, after hearing 8 hours of testimony, he goes back into his chambers and he deliberates on it for a little over 3 hours. And at 12:47 a.m. the following day, on March 11, 1906, he announces his decision. And his decision, which is a matter of public record, the way that judicial decisions, all federal decisions are recorded by the federal government as part of the National Archives Act. So you can actually, if you want to go looking for this, you can actually read the entire decision that Judge Clark sets out. But what his decision states that counsel were absolutely, to an extent, terrorized on the account of the fear of the mob. He indicated he had doubts about the state's case against Mr. Johnson. However, because there's always a however, because again, remember, we're dealing with new law right now. Mm-hmm. He did not believe that the Constitution actually authorized him to grant any type of habeas petition, because this has never been done before. This is new law. And the the district court is like, I agree with everything that you said. I don't think I have any authority to do anything about this. So I don't know what you want me to do. I'm sorry. I don't know that I can do anything. What he does do, however, is he does grant a 10-day stay of the execution to allow for Mr. Johnson's attorneys to appeal directly to the Supreme Court of the United States. This is the first time that the Supreme Court of the United States is being asked to weigh in on a death penalty case.
Wow. And so where do we go from here? How long did it take maybe for the Supreme Court to acknowledge it and then step in, given a 10-day stay of execution?
It became complicated.
I can imagine.
The newspapers were not kind, to be polite. The newspapers all throughout Tennessee, even newspapers that might have been inclined to be sympathetic to Ed Johnson's situations, they did not take the stay of execution particularly kindly. Judge McReynolds claimed that federal judges had no authority to issue stays in state criminal cases, which was a legally sound argument at the time. The Tennessee governor granted a 7-day stay of execution instead of a 10-day. So we've got a little bit of a brewing conflict right here already. As to how long the stay of execution is. Is it only going to be 10 days or is it going to be 7 days? The more important thing is the governor at least was willing to give him more time than just 2 extra days. And the newspapers, like basically every lawyer that was interviewed by the newspapers said that this is a frivolous appeal and it's going to get rejected pretty quickly. Because again, there's no known authority at this moment in time that this is a legally sound argument. The law offices, I mean, Mr. Pardon and Hutchins, their law offices, it was burned to the ground on March 15th, which again just goes back to one of the issues that Noah Pardon was concerned about was their own physical safety. Rocks were thrown through Style Hutchins's windows, and gunshots were fired at Mr. Pardon's house. So again, they're under siege on this one. So yeah, it's a bad situation overall. But even through all of that, Stiles and Hutchins, Pardon and Hutchins still work through it. And on March 16th, so 5 days later, they get an official appeal for the denial of federal habeas relief at the Supreme Court of the United States. So this is the first time that the Supreme Court is being asked to rule on a state criminal case. More importantly, it's also the first time in history that a Black attorney is potentially going to be the lead counsel before the Supreme Court of the United States. This is, again, not anything that's ever happened. Remember, as I mentioned in the last episode, this is the Civil War ends, 40 years ago. The concept that's how long we've had Black attorneys at this point in time, is like about maybe 40 or so years. So this is the first time potentially that a Black attorney is going to be lead counsel, and they lucked out amazingly in the justice that heard their appeal. The justice that heard their appeal for the purposes of the stay of emergency execution was Justice John Marshall Harlan. And Justice Harlan is an absolutely legendary character in the history of the law. He was born into a slaveholding family in Kentucky. Despite that, when he became of age, he supported the Union at the time the Civil War broke out. He arranged and led one of the volunteer divisions in Kentucky. He was eventually appointed to the Supreme Court of the United States as an associate justice, where he was the only justice to write a dissenting opinion on the case of Plessy versus Ferguson. Plessy versus Ferguson is decided about 10 years ago, 1896. That's the decision that enshrined segregation as the law of the United States at the time. John Marshall Harlan is the only justice who dissents from that opinion. So not only is there appeal in front of that, the other amazing thing about John Marshall Harlan is his grandson was also on the Supreme Court of the United States. It's the only time that you've ever had two family members on the Supreme Court. They were not on the Supreme Court at the same time, but Justice John Marshall Harlan II wrote the unanimous decision in Brown versus Board of Education, which overturned Plessy versus Ferguson. So the John Marshall Harlan legacy is again something that that fortunately is a lot more celebrated. Both Justice Harlans are very well regarded, but that's an amazing stroke of luck for Stiles, Hutchins, and Noah Pardon. That this is the man that gets to hear their appeal on staying the execution.
Right. Of all the options that would have existed, I mean, I'd say you drew a pretty good hand, but boy, were they due one, and boy, was Ed Johnson due one by now. So walk us through, Justice John, Harlan going through this process, weighing the different factors of this case. What does this all look like, and how does it shake out within the Supreme Court itself?
Well, what ends up happening is the way that these types of appeals work, the way a petition for certiorari worked back then, the justices were, and they're still technically to an extent, they're assigned individual circuits that they review the petitions from. The difference was back in the early part of the 20th century, those arguments were a lot of times made directly to the justices, especially if it's an emergency situation. So Noah Pardon has effectively a private audience with Justice Harlan and argues that there were very specific violations of the 4th, 5th, 6th, and 14th Amendments, argued that the atmosphere in the community was so poisoned that it was impossible for Ed Johnson to receive a fair trial from an impartial jury. Everyone went into that courtroom knowing what they were going to do. They were there to give him a trial, and then they were there to hang him. So it takes 2 days for this process to go through. And on March 18, 1906, Noah Pardon steps on the platform from his returning train in Chattanooga, Tennessee, excitedly greeted by Style Hutchins. During the time frame that Noah Pardon was on his way back from Washington to Chattanooga, Styles Hutchins receives a telegram from Washington, D.C. That telegram reads very specifically, "Have allowed appeal to accused in habeas corpus case of Ed Johnson, signed John M. Harlan, Associate Justice." It seems like they have finally won. The federal court has stepped in. The Supreme Court has said, we will hear the federal claim. The execution's off. It seems like finally there has been some forward progress and something that represents a win as far as Ed Johnson is concerned.
Oh my gosh, a win indeed. And, I had just mentioned last time I popped on screen a win and getting Harlan to be a part of it. Clearly, Harlan delivered for Ed Johnson and the team. So they get this win. It's the first one that they've likely seen. I mean, since this all blew up and began. Walk us through what this means for Ed Johnson. Obviously, aside, from the execution being off, but where does this take Ed Johnson moving forward, and how does this thing, really play out in the Supreme Court?
Unfortunately, it does not play out very well for Ed Johnson. If you recall, in the first case, when the district court of Tennessee ordered a stay of execution to allow for a appeal to the Supreme Court of the United States, the newspapers were not particularly happy about the federal court sticking their nose into the state court business. Being told that the Supreme Court was sticking their nose into a state court business went over worse. It did not take long for the citizens of Chattanooga to make everyone aware what they thought of this. On March 19, 1906, the next day, dozens of armed men stormed the Hamilton County Jail. There was absolutely no resistance there. Sheriff Shipp claiming that any talk that anyone was talking about of a lynching was absolutely nonsense, took the decision of giving every single one of his deputies a night off. So Ed Johnson is all alone in his jail cell in basically an empty jail, or certainly empty of anyone who might possibly protect him on this. And a couple dozen people have now shown up to storm the jail for the third time. And unfortunately, this time Ed Johnson's actually in that jail. It took 3 hours. The attack on the jail starts about 8 o'clock in the evening. And the mob is using old-style sledgehammers to basically break down the iron bars to get into Ed Johnson's cell. So Ed Johnson is on the opposite side of a cell watching an angry mob take sledgehammers to his cell door, beating it down, just pounding it over and over again, mostly because he was forced to by other people. Sheriff Shipp did actually show up at the jail to respond to the mob, but he was told that he needed to turn around and go home, to which the sheriff basically shrugged his shoulders and turned around and went home. Leadership in action, ladies and gentlemen.
Yeah, I mean, talk about Shipp making one positive move for Ed Johnson earlier on. It's like it seems as if he reached the point of no return. He made his decision. Let's put it that way.
Exactly. So Shipp leaves. The deputy, the 72-year-old jailer with the leg injury, he's escorted out. It takes 3 hours for the mob to break their way into Ed Johnson's cell. So just think about that from a psychological standpoint. 3 hours of people
sitting there,
sitting there. It's horrible. So
after everything you've already been subjected to,
exactly.
Oh my God,
exactly,
I mean, just terrible, absolutely terrible.
So they drag him out of the cell. They drag him. They drag him to the local bridge that spans the Tennessee River. They put a noose around his neck and they tell him that he might as well confess, since there's absolutely nothing he could do to save his life. Naturally, this is getting a sizable crowd, so there are newspapers there. Because, of course, there are newspapers there. Newspapers are responsible for all this mess in the first place. But the newspaper reporters, they're reporting that Mr. Johnson maintains his innocence while addressing the crowd. And the quote that is attributed as being his last words are, "I am ready to die, but I never done it. I am going to tell the truth. I am not guilty. I am not guilty. I have said all the time that I did not do it, and that is true. I was not there. God bless you all. I am innocent." Those were his last words. The crowd went absolutely insane. They started lifting his body into the air by his neck. And again, this isn't a hanging. This isn't a situation where you're held by a noose and your neck snaps as it drops. You are being strangled as you are being raised off of the ground. That's what this crowd was doing to Ed Johnson. So they've got him up there, and as his body is swinging, he's not dying fast enough. So the crowd just starts opening fire on him. And the autopsy report indicates that he was shot approximately 50 times while he was suspended in the air. And then after his body falls to the ground, it eventually, one of the shots hit the rope, broke the rope, he crashes down. Even despite the fact he's very clearly dead at this point in time, someone walked up and shot him point blank 5 more times. And to add more insult to injury on this, they left a note on his body that said, "To Justice Harlan, come get your attractive and successful African-American now." I think you can imagine what the word actually was. But unfortunately, even though we're going over historical text and historical accuracy, I don't want the channel to get stricken because that's what YouTube does these days, as does Facebook. Side issue though, but that's the situation that we've got there. That's what's happened. And it did not take long for news to reach Washington on this. The Supreme Court of the United States and then President Roosevelt learned of the lynching the following day. And to say that no one knew what was going to happen next is an understatement. Justice Harlan, who signed the order granting the habeas petitions we mentioned a moment ago, told the Washington Post that Johnson was tried by little better than mob law before the state court. He had the right to a fair trial, and the mandate of the Supreme Court has, for the first time in the history of the country, been openly defied by a community. The New York Times had a similar sentiment, stating that the open defiance of the Supreme Court of the United States has no parallel in the history of the court. No justice can say what will be done. All, however, agree in saying that the sanctity of the Supreme Court shall be upheld if the power resides in the court and the government to accomplish such a vindication of the majesty of the law. Teddy Roosevelt wanted to send the United States Army into Chattanooga. That's how angry he was about the situation.
Wow. Yeah.
He got talked out of it by then Attorney General William Moody. He got talked out of sending the Supreme Court down there. He did send the Attorney General and 2 Secret Service agents down to Chattanooga to investigate the lynching. The investigation lasted for 3 weeks, and on May 28 of 1906, Attorney General Moody did something that has never been done before or been done since. He filed a petition charging Sheriff Shipp, 6 deputies, and 19 suspected leaders of the lynch mob with contempt of the Supreme Court of the United States.
Wow.
The justices unanimously approved the petition and unanimously agreed to retain original jurisdiction of the case. If you remember to our first episode, there are 2 types of jurisdictions. There's original jurisdiction, which means this is the trial court. We are hearing everything. And then there's appellate jurisdiction. And most of the Supreme Court's decisions are based off of appellate jurisdiction. It is uncommon for the Supreme Court to have original jurisdiction over anything. Right. But this time they said, no, this is our case. This is original jurisdiction. So on October 15, 1906, the United States Marshals were finally able to round everybody up. And on October 15 of 1906, Sheriff Shipp and 25 co-defendants became the only persons in the history of the United States to stand before the United States Supreme Court and plead not guilty. And they posted bond to be released from jail. Wow. First and only time that's ever happened. So what ended up happening is obviously, again, this is an original jurisdiction situation. you've got all your original trial motions, things of that nature. One of the
Sure.
first things that the defendant's attorneys did is that they argued that the Federal Habeas Corpus Act of 1867 meant nothing, that it didn't authorize the United States Supreme Court to intervene in a state criminal proceeding, didn't authorize federal courts to intervene whatsoever, and that there was no such thing as a federal right of habeas corpus. The motion to dismiss, in addition to arguing that the Federal Habeas Corpus Act didn't exist, they also argued that the court didn't have any actual legal authority to stay the execution or declare him a federal prisoner while it considered the habeas filing. Because the Supreme Court's original order stating the execution was invalid, the argument was that the justices could not legally find the sheriff and any other individuals guilty of violating an illegal order. The argument being you cannot violate something that is already illegally ordered.
Sure.
So that was the argument, and there was a lot of smart money that said that might be accurate. Again, as I mentioned a couple times already, the Federal Habeas Corpus Act of 1867, it's new law. It's never been litigated. It's never been tried. No one knows what it does. No one knows what federal constitutional rights are as relates to state criminal proceedings. So there were a lot of attorneys out there, very smart attorneys and very good attorneys, who all says like, that's a pretty good argument. That actually might work. It did not. And the court unanimously rejected that argument, and Oliver Wendell Holmes, one of the great justices that ever sat on the court, it wasn't a long decision. They could have just basically said denied and sent it back, but of course, because everything's on new ground with this, they're trying to kind of justify everything they're doing. But it's a relatively short decision. It's about a one-page decision, and Oliver Wendell Holmes writes in the decision denying the motion for dismiss. He writes, "This court and this court alone has jurisdiction to decide whether a case is properly before it, and until its judgment declining jurisdiction is announced, it has the authority to make orders preserving the existing conditions, and a willful disregard of those orders constitutes contempt. The power and dignity of this court are paramount." So basically, a very verbal smackdown that says our jurisdiction is what we say it is. You don't get to decide our jurisdiction, and you broke the rules. So now you get to see what the consequences are. So the trial continues. And in very stark contrast to the trial that Ed Johnson received, the trial of United States versus Shipp starts on February 12th of 1907. So just over a year after Ed Johnson is sentenced to death for a crime he almost certainly did not commit. That's when the trial starts, is in 1907. To oversee the taking of testimony and the admission of evidence, what the Supreme Court did is they appointed their deputy clerk as special master for the proceedings. What we would refer to that as these days, they basically appointed a magistrate to kind of deal with the preliminary issues for the trial, because even though the Supreme Court was still was maintaining original jurisdiction over this matter, expecting them to actually sit through an entire trial was probably a little bit ambitious. So they appoint their clerk as special master. He's basically a magistrate to oversee everything. The presentation of witnesses, cross-examinations, and the admission of evidence took place at the federal courthouse in Chattanooga, Tennessee, which was about 9 blocks from the location that Ed Johnson was lynched. None of the justices actually attended the proceedings as they were unfolding, but they were getting briefs, they were getting information sent back to them and compiled. It took over a year for this phase of the trial to happen. So witnesses are sworn, evidence is heard, motions are constantly being argued. What ended up happening at the end of the day is, based off of those arguments, based off of the way the evidence unfolded, the court did dismiss almost all of the defendants. Sheriff Joseph Shipp and 8 other individuals were maintained as defendants. 17 of them were ultimately dismissed as defendants for lack of evidence or lack of support. So these guys, unfortunately, get a very thorough trial. They get a very fair showing in the situation, and a lot of them get away with it. So now that all that's done, and now that we're down to basically the final 9, on March 2nd of 1909, so 2 years after the trial starts. This is technically an original jurisdiction situation. Their trial takes 2 years. The lawyers for both sides meet in the basement of the old Senate chamber. Which is where the Supreme Court was. This is the Supreme Court building that exists now, has only been there since about 1920. Before then, the Supreme Court met in the basement of the Senate. This is where the final arguments are happening. Both sides are given a full day to argue their case. The lawyers for the defendants get a full day to argue their case, and the Attorney General of the United States is personally making the argument to the Supreme Court. The justice deliberated over the decision for 5 days. And in April of 1909, they reached their decision. And 5 of the 8 justices, and the reason there's only 8 justices deciding this is William Moody, who was the Attorney General under President Roosevelt. Before Roosevelt left office and before this case made it as far as trial was concerned, Moody was nominated to the Supreme Court. So he recused himself from hearing the case based off the concept of conflict of interest. He investigated it as an attorney. It would be improper for him to sit on it as a judge. So there's only 8 justices that are actually hearing this case.
Sure.
And of the 8 justices that actually heard the case, 5 of them believed that Sheriff Shipp and the co-defendants were guilty of disobeying an order of the court. The disagreement arose regarding the meaning of the verdict. Some of the justices believed the verdict was exclusively about preserving the integrity of the court, while others believed the court needed to send a message that lynch law would not be tolerated in this country. That's why there was a split. They all agreed that sticking your thumb in the eye of the Supreme Court, that's not permissible. We're not going to allow that to happen. 5 of the justices thought that that's what needed to be done. 3 of the justices thought, it's like, no, not only do you not stick your thumb in the eye of the court, you also don't get to lynch people. So for all the people who think that it's just the modern era that the Supreme Court is really divided and really acrimonious, this is a decision where someone flaunted the court's authority and they still can't reach a unanimous decision on it. So
wow. Yeah.
Again, the more things change. The decision finally comes down. The decision's finally delivered on May 24th of 1909. Chief Justice Melvin Fuller personally delivered the verdict. That was a little bit unusual during the history of the court. Chief Justice Fuller did not like reading the decisions. He tended to allow other justices to write the decisions, other ones to write it. Due to the nature of this case, he believed that it was important for him to personally deliver the verdict of the court. And that verdict found Sheriff Shipp, one of his deputies, and 4 leaders of the lynch mob guilty of contempt. So even after that trial, there were defendants who were found to be not guilty. There were 4 of them who were found to be not guilty of that process. And the decision, Chief Justice Fuller starts by saying, "It is apparent that a dangerous portion of the community was seized with the awful thirst for blood, which only a killing can quench. The persons who hung and shot this man were so impatient for his blood that they utterly disregarded an act of Congress as well as an order of this court. When anyone in custody is at the mercy of a mob, the administration of justice becomes a mockery. When this court granted a stay of execution on Johnson's application, it became its duty to protect him until the case should be disposed of. And when its mandate issued for his protection was defied, punishment of those guilty of such attempt must be awarded." So they were found guilty. They come back on November 15th of 1909. The remaining defendants appear before the court to receive their sentences. Sheriff Shipp and 2 of the deputies were ordered to serve 90 days in jail. The other 3 defendants were only ordered to serve 60 days in jail. The sentences were going to be served at the United States Jail in the District of Columbia, and all 6 defendants were ultimately released early for good behavior.
Man.
I would like to tell you, there's a happy ending somewhere in this.
Yeah. We've been longing for
Yeah.
it this whole time, Jack.
And unfortunately, there's not. What ends up happening is when Sheriff Shipp returns to Chattanooga on January 10 of 1909, he's given a hero's welcome.
Sure.
There was a monument that was eventually erected in his honor. I was about to say I encourage any of our listeners in Tennessee to maybe check that one out first, but legally I have to tell you not to do that. So, no one's going to be sad if that statue falls down, but I have to legally tell you not to attack it. Samuel McReynolds, the judge who originally oversaw Ed Johnson's trial, he went on to serve in Congress for 18 years.
Mm-hmm.
Noah Pardon, Stiles Hutchins never returned to Chattanooga after the lynching. They were so terrified for their lives, almost rightfully so.
Sure. No,
They
understandably.
left. Mr. Stiles moved to Taft, Oklahoma, and gave up on the practice of law entirely. Noah Pardon moved to East St. Louis, Illinois, where he did continue to practice law for the next 40 years. The thing that makes this case, aside from, again, just the general tragedy of the lynching of Ed Johnson as a whole, the thing that makes this case doubly tragic is if the mob hadn't murdered Ed Johnson, Noah Pardon and Stiles Hutchins would likely be remembered as two of the greatest litigators of the 20th century. Like I said, this would have been the first time that a black man argued an attorney before the full Supreme Court of the United States. In addition to simply that precedent, historical instance, the important thing is every single one of his arguments were right.
Airtight. I mean,
every single one of them was right. The Supreme Court over the following years that the Supreme Court would rule the right to a fair trial is undercut by the threat of mob violence. They would agree that defendants have to be afforded the right to effective assistance of counsel, that criminal trials have to be open to the public, that there is a federal right to a fair trial in state proceedings. States can't systemically exclude potential jurors based off of race. And state criminal defendants do absolutely have the right to sue in federal court if they think that something was done wrong. Every single argument that Pardon and Hutchins made, they were right. They were right about a law that no one knew what it did, that no one thought was going to work, and they were absolutely 100% correct.
Yeah. Well, I mean, Jack, there is so much that goes into this case. Obviously, we don't get the rainbow, the pot of gold at the end of what is most certainly not a rainbow. But what we do get is a wild story. We hear about some incredible, firsts in judicial history. And then also there are some incredible characters, like Parsons Pardon and Hutchins. My mistake. Pardon and Hutchins. There's a lot of unbelievable information that pertains to this case. And the reason that we, wanted to pick it and also kind of titled our show today is the idea of this forgotten legal landmark is I would probably wager to say that most of the average Joes out there, this is not one of those cases that's in the, deep in the back of the brain that they remember from maybe government class in high school or college. It's one that is really a forgotten legal landmark. Jack, any final thoughts, really maybe just thinking about the importance of the case on history, any final thoughts that you have for us in regards to this? And
making history is rarely a clean process. The history of the law is actually even messier. The reason that this is a forgotten precedent is again, this was the first time that the Supreme Court ever inserted itself into a state criminal proceeding. So all of the incredibly important decisions that came about in the years that followed, like Miranda versus Arizona, like Gideon versus Wainwright, like any stay of execution that the courts ever granted. This is where it all started. This is ground zero for modern federal jurisprudence as it relates to the several states. After this, the states were aware that those decisions could be reviewed. I'd like to say that they cleaned up their act, but again, that would be optimistic and accurate. Congress has, over the years, not exactly been friendly to that. In 1996, the Anti-Terrorism and Effective Death Penalty Act highly limited the ability of the Supreme Court to review federal state death penalty cases. But there is still an avenue to be able to get in there to review them. So just because the jurisdiction has been limited doesn't mean that that it's over. I will say that with one last thing with regards to Ed Johnson, you can actually still visit his gravesite. His grave is still there. It's managed to survive. It's an old Negro cemetery on Missionary Ridge, just outside of Chattanooga. Ed Johnson's still buried there. His gravestone's still there. His headstone is in horrifically terrible disrepair. There was not a lot of money for it in the first place. There's not really been any significant effort to preserve it or maintain it, but it's still there. And on the headstone are his final words: "God bless you all. I'm an innocent man." And he almost certainly was. And that's the worst part about all of this.
Yeah. Yeah. Part of me thinks that, the fact that he's still, after not only the craziness involving the trial, the multiple attempts, with mobs coming into the jail, then 3 hours of pounding on jail cells, for the mob to get in there and to get him, the fact that he still had the good nature to say, "God bless you," as a final word. Quite a thought, quite a concept, honestly.
Definitely a better man than a lot of us would be.
Amen to that. So look, Jack, I really appreciate you kind of, unpacking what is 2 episodes worth of a suitcase on this on this topic, this forgotten legal landmark of United States versus Shipp. It was certainly an education for myself going through and getting ready for these episodes with you and learning. And I am, if there's one thing that I'm excited about with our show here in Closing Arguments is these other case studies that we're going to jump into, some other awesome legal landmarks, not only, personally to you, but also, personally to all of us, Supreme Court legal landmarks. We've got a lot of great conversations ahead, a lot of great episodes that we're going to be diving into on the show moving forward. And I'm really looking forward to that. So thank you for your time today, and really over the last 2 episodes to kind of, showcase this forgotten legal landmark to us all.
Absolutely. As always, it's a pleasure. I promise our next episode is going to be far less sobering and far less of a gut punch. But again, history, you have to know how history is made. You can't avoid it. That's all there is to it.
Yep. Well, and hey, we planned a little bit more of a light and heartening episode next time. That's how we planned it. So hang with us. Don't worry. We're not all doom and gloom here. But no, appreciate you, Jack. Take it easy. Thanks for joining us. And look, hey, we want to say one final word as a thank you to our audience for jumping aboard these last 2 episodes in particular. Hey, if you like the show, you're enjoying these kind of case studies, these, legal proceedings, and honestly, these closing arguments, if you will, do us a favor, like the show, comment on it, subscribe to whichever platform you're checking us out on. And then, of course, share this information with friends, family, anybody who would enjoy these types of conversations. At the end of the day, we're diving into, criminal law related discussions that Jack and his team over at Razumich and Associates are knee deep in every day. We've got a lot of great conversations, a lot of great case studies that we're going to be jumping into in future episodes. We would hate to have you miss out on any of those. So for Mr. Jack Razumich, I'm Ryan Ruff. We're going to go ahead and say so long today. We thank you so much for joining us on today's edition of Closing Arguments.